All right, students, welcome to chapter 39, lecture for BUL 3130. Kind of late in the week. I wanted to get this out there so you'd have it, if not for the quiz, for the review when we get ready to come up on the final, which is only a couple of weeks away. We are at that ending point. We have this week, and then next week will be our last new material, and then we'll move into the final. A couple things before I get going with this. I have posted 35. It is a lecture from last semester. The material hasn't changed, so it's not a issue as far as material goes. So make sure you view it. And before I get started with this one, let me go ahead and let you know about a couple of things that I would really like for you to take care of. I have posted a link and a announcement from either the end of last week or the beginning of this week. That is a link to the evaluations for the course. Please go in and do those. I do read those. I read your comments. I read the ratings. I pay close attention to those, and I make adjustments based upon what you're saying that you need in the class. So whatever you put in there now will help me, and it'll help the students going forward that take this class. So please go in and do those. It'll be great help for me. So that is kind of where we're at with those. And like I said, that winding down process, or we'll use a business term, a winding up process of the term as we get ready to reel everything back in that we've learned since the midterm and get ready for the final. So let's go ahead and get started with 39. With chapter 39, we have intellectual property is what we're looking at. And this is one of those things that from surveys and from a discussion post that will be posted beginning of the week, next week, that you'll be able to do that'll where you give me some insight in what you would like to have in the course. Well, this is one of those things that over the last couple of semesters students have been asking for is a section on intellectual property, and your book actually has that. Chapter 39 deals with intellectual property and what goes into it. So I wanted to add it into this semester, and give me some comments on this when you do the surveys or when you do the discussion posts that we get ready for. Give me some comments on what could be added to this, what may be interesting to you, because I know this this is a big thing, especially with the with AI and a lot of other things that are out there. Protecting what you create is real important to a lot of people. So no matter what you're doing, business world, personal world, things you create, if you're an artist or anything like that, your ability to protect it and make sure that it's yours is very important. Now, this goes, pretty deep into the corporate side of it, the business world side of intellectual property. But intellectual property can be anything that is created by a person. They have it's economically significant type of intangible personal property. Remember, intangible and tangible to make sure that those are clear. Tangible is something you can hold. You can hold a laptop. You can hold a comb. You can hold a drinking bottle. Those things are tangible. Intangible is something you can't actually put your hands on, but it is something that is owned. So intangible personal property is something that is owned by you that you may not be able to actually put your hands on. The examples this gives are like trade secrets, trade symbols, copyrights, and patents. So really and truly, pretty heavy into the business side of it. But if you're a writer and you write a book or you write anything that is going to be published, you may want to put a copyright on it so that it's protected and someone can't take it. If you have a certain type of item that you produce, you'll want to make sure that it's protected, the production process of it, trade secrets, a patent on it so that no one can recreate it. I apologize for my I apologize for my voice a little bit here. It's trying to go on me. I was working in the yard yesterday, so I think just a little bit, a lot of outside and breathing in a lot of outside pollen and stuff is kind of rough. Washing it off the car probably stirred it up pretty good. But when we think about what it goes into intellectual property and what the various pieces of it are, as we go through this, consider it for the business section, but also consider it for your own personal creations. I've had students in the past, and I'm sure there's some current students that have, you have a business or you have something that you create that you put out for consumption, and you want to make sure that your creation is protected. So that's where the intellectual property comes from. Trade secrets for the purpose of this can include customers list or contracts of various types. Those things are protected. Formulas, processes, of course, and production methods that a business uses to succeed that they would only use, and protecting that information is vital to their business being successful. If they couldn't protect it and others could use it, well, they could lose whatever niche in the business they have, and it could be a problem for them to lose out on what they're doing. That's the reason that a lot of corporations will protect just the way they produce something. They may produce an item that's very similar to another item. You see it in the pharmaceutical industry where you have drugs that treat the same thing produced by different corporations, but it's all, a trade secret. The exact process of that is protected. They file that, and it's not until later on when there's an allowance for generic versions of it to come out that those secrets begin to, be expanded. This is also how a lot of manufacturers of things like computers and chips and different items like that, they have a specific way they do stuff, something they do different than everyone else. That is a protected bit of information. So it's a method or something that they do that's protected in their business sense that keeps them successful. The owner of a trade secret, they can obtain damages or injunction if someone was to misappropriate that secret. In other words, they get a hold of it and they use it in some way that it shouldn't. Whether that's an employee or a competitor, they can, file a suit against them to try to get that compensation for the misuse of their information and their production secrets. Trade symbols are the things that we see. So we may not see what goes into the trade secrets, but trade symbols, we do see those. So those are things like a trademark. Most companies have a trademark. For Walmart, the yellow asterisk or star with inside that blue field is their trademark. And Target, very similar. They have the red and white Target, the red circles on the white field. That is a specific trademark for them. They can, if someone else uses it in some way that they don't approve, they can then sue them for use of their trademark. That's a very distinctive symbol to them, and a lot of businesses have it. Windows has the four squares and various shapes that are all the same color, even through all the different iterations of Windows. That hasn't changed other than just a little bit of stylization, or as graphics have improved and they can make it different, they did. So that's one of their trademark symbols that they use. So those are very important. Those, if you see those, you know, okay, that's Walmart, or that's Target, or that's Windows. So when you see those type of trademarks, that's the reason those are protected, and why we would want to protect the trademark when we create one, so that no one else could, put out a product or put out a service or whatever and put a symbol. So so close to ours and so similar to ours that consumers will be confused and purchase that one thinking they're purchasing our product, and that product be of a lesser quality, and our reputation take a hit when it was never actually ours. So if we can protect our trademark and closely monitor how that's being used, and if someone is using something similar, we can protect not only our business but protect our reputation at the same time. There are certain service marks that may be a distinctive symbol again, or a word or design that's used to identify provider services when they do certain services. Certification marks or symbols or words, once again, uh, that are used with goods and services to certify specific characteristics. There are certain seals that corporations will use that is their seal that shows it's been inspected, it's been approved, and that it has their seal of approval from their corporation. Collective marks to indicate membership in an organization. Some of those, a lot of organizations have use different symbols on business cards or membership cards. No matter if that's a physical or a digital version of it, there's a certain symbol that, if you do not see that symbol, it wouldn't be it. One of those, one thing that kind of fits in all these is sporting professional sports leagues. MLB has the batter holding the bat with the ball in it. They have a holographic version of it that fits on most things, and that's, if you do not see that, it's not there. And then registration to be registered and thus protected by the Lanham Act, which is the act that protects a lot of these different symbols and things. A mark has to be distinctive, not immoral, deceptive, or scandalous. So it has to be a distinctive mark, and that is the big thing with all of these, is that there has to be some distinction from what's been done previously. If you want to see how confusing and hard that can be sometimes, just play around with trademark building or logo building and create a logo, just something you want to create. And because we've seen so many of those, we have a tendency to pull in from what was eye catching to us. And then once you create that logo, put it on use a service that will check it against other trademarks and see how quick you'll get, a notification like this infringes on this, or this could be too close to that. It's real easy to do that. So you have to be careful when you're creating your logo, your trademark, and you're getting, your product ready to go, that you're being distinctive in what you're doing. All right. So when you get ready to register your trademark or your service mark, whatever, it needs to be so distinctive that it doesn't resemble any other one in a way that could be construed as copying it or infringing upon their trademark right. Infringement is what happens when someone, a person, or an organization, without prior authorization, they use a substantially indistinguishable. Okay, now let's keep that in mind. The term substantially indistinguishable. Oh, went too many. So this term is what the lawsuits and intellectual property law builds upon that term, substantially indistinguishable. It's a mark that is likely to cause confusion, mistake, or deception. So if we were to look at something like a Walmart, their symbols. So I talked about a few minutes ago, or a few slides ago, where Walmart symbol currently is the asterisk or star, whatever you want to describe it as, that is normally yellow on a blue field. That is what their common trademark is now. A few years back, it used to be a smiley face. Well, that smiley face is not so indistinguishable because it is used on a lot of different things. And because of different issues that arose, the use of smiley face in shirts, there has been a copyright on the bright yellow smiley face. And so there were some changes that took place, and they went to a more distinguishable item for their use. And one that really and truly, if you were to use that, it's going to be real easy for them to understand, or somebody to see, oh, that's a copy of the Walmart symbol. So it's one that, if it was still the smiley face, well, we put smiley faces on everything. People that like to use emojis when they text, they may put a smiley face in there that's real close to what was the Walmart symbol. So that change into the symbol they use now, that trademark, was to make it uh, so unique and so distinguishable from other trademarks that it's easier to see when someone infringes upon that. So a trademark needs to be that way. So as this said, it must be distinctive. Okay, so it's very distinctive. So when we look at that to see if something is substantially indistinguishable, a yellow star on a blue field is pretty easy to see. If it looks like the Walmart asterisk or star, whatever you want to call it, that's gonna be okay. Well, that looks like it. But what if you invert those colors? You're still using the same symbol in the same color, so that is not substantially indistinguishable from what their mark is. So you need to have it something to be so different, so dissimilar, that there's not a confusion, because it's protecting the corporation who has that mark, who their reputation is tied to that. And I've said it a couple of times, and the important part of this is that the reputation of a corporation is tied to their trademarks, their symbols, the things that we see, their forward-facing items, their forward-facing marks and distinguishes. Those things are what we see. We understand as soon as we see them what they are. It's if I was to just show you a screen of trademarks and symbols like that and ask you to pick them out, most people, if you put 10 on a screen, can pick out at least 8 to 9 of those real quick. There's not a lot of thinking about it. Oh, that's Walmart, that's Target, that's Windows, that's Apple. The Apple with the little bite taken out of it. Everyone knows what that is. And those things are set. And if you infringe upon that, you're infringing upon not only their symbol, but their reputation, their product line, their business. And so that's why it's protected like it is. So something has to be substantially indistinguishable for it to be used. So it has to be to a great deal, substantially, a great deal different, indistinguishable, or distinguishable from it. So it has to be a great deal distinguishable for it to be shown that it is infringement. All we have to do is that it's a great deal indistinguishable from it. So it's so similar to it that, it looks like it will cause confusion, mistake, or deception. It's that confusion, that mistake, or deception that, or what we look at when it comes to those items. So we want to make sure that we're not infringing in that way. Definition of trade names is any name used to identify a business, location, or occupation. That's your trade name. It's protected under the Lanham Act, but infringement is may not be registered under the Lanham Act, but their infringement is prohibited. Infringing upon someone's trade name. You can't call your product Windows, even if they are Windows. You can't call your product, your store. You can't open a store up and call it Walmart. Those type of things make sense, right? Trade names. The damages and injunctions can be sought for those infringement. I don't know how many of you ever seen the movie Coming to America, or the sequel to it, McDougal's. Was definitely a ripoff of McDonald's, but it was one of those things where it was a lot of infringement upon some copyrighted material. Now, where that doesn't apply And what we may not have talked about as much as, because of adding some extra things in, franchisees. So when you have a franchisee, they are paying to be able to use those trademarks. So the McDonald's you walk into in your neighborhood, they may not be owned by McDonald's Corporation, but the person who owns the franchise, they have paid McDonald's a substantial amount of money to be able to use a bag with the golden arches on it, a cup with the golden arches, that, unmistakable, fry box, the red box with the, golden arches in the middle of it. Those things are paying for. So that's not infringement. They're paying for it. It's when it's not being paid for and it's being copied to a certain extent. The golden arches on any box that looks like a fry box is going to be something that's not, it doesn't fit substantially indistinguishable because, well, that box of fries, McDonald's is known for their fries, those type of things go into that consideration. So when, those things are looked at and that infringement, that's kind of where it comes from. So a trade name, something similar to McDonald's, something similar to Target, those type of things, opening up a store with a, having a symbol that is blue and white, or even if you just reverse it, have a red background with a white target or bullseye on it, and calling the store Bullseye, it's pretty easy to see what you're trying to copy there. So those type of things are where infringement comes in, because it's pretty easy to see where the copy is and what you're trying to do there. The next thing we want to look at is copyrights. Now, copyrights are interesting. All right. So, definition of copyright is an exclusive right, usually for the author's life plus 70 years to original works of authorship. All right. So, let's think about some things that, their copyrights end. So when someone passes away and then they get, after 70 years of them, after they've passed, that copyright ends unless someone renews it, but in most parts of the original works of authorship, that copyright is going to end. We've had a whole lot of things that have come into the open market, if you will, such as, that original version of Mickey Mouse, the Popeye the Sailor Man, an original version of that character, Winnie the Pooh, and things along those lines. And people have just, began to make money based upon those earlier iterations of it, because they're now open to be used, because copyrights and trademarks, began to go, those type of things. So having your copyright is very important to protect it, to keep your creation from turning into everybody's way to make money. So registration for that, they're not required, but it provides an additional remedy for infringement. A copyright, to a certain extent, you can set up a basic copyright by just making sure that you date when a creation is done, have something that, not a handwritten date that anybody could put, but some way of proving a date of when it was created. If you're writing out sections in a book and you're doing the old, the old fashioned way that some of us older people still do, we write stuff on paper, you can mail it to yourself. The date stamp is proof of when it was created. If you're doing it digitally, your computer tracks when you're typing and what you're doing, and when you save stuff, when you save it, there is a stamp that says it was saved here. When you create videos, if you're you create videos for social media, maybe you're wanting to be an influencer and you're creating stuff, your copyright could be based upon that first time you produced a certain reel or a certain video or whatever it may be. So those type of things are where you can get some protection in there, but it's always a good idea, especially if you have an item that you're really going to put out for a lot of consumption, to register a copyright You can do that, through copyright offices. These are all federal things also. The copyright trademarks and all are federal uh, items that you do. So you go on their website to get those type of things done. All right. Copyright protection provides exclusive right to reproduce the copyrighted work, prepare derivative works based on the work, to distribute your copies of it, and perform or display the work publicly. That's your protections under copyright. Now, you can give those rights to someone when you purchase for anyone who does any type of production of music or videos, especially short videos like reels and things along those lines, shorts on YouTube, those type of things. You can purchase a license at different levels for the music you may use for it. So not to put a plug in for anybody in specific, but there is a software company called Magix. They actually work with a couple of other companies. They have a bigger umbrella in there, but you can buy music through them, and you can buy just samples of music, or you can buy whole songs that are created through creators. They're not songs like you would hear on the radio, but they're created items, and you can get a basic license for them, which means you can use it for your own personal use. You can step up and get one that means it can be used for educational purposes. Then you can go to one where you can get a commercial license. And what you're doing is paying for different levels of their copyright. So they're allowing you, to use their copywritten things just for your use, similar to what we do with books. When we get a book and we quote it, the way we're able to use it is because we're quoting where it came from. When I'm kind of a stickler for that APA, as most of you have learned throughout the time we've been doing case studies, what you're doing is meeting the copyright rules for using that book and putting it in your own work. You have to quote it. We know that it's plagiarism if you do not, but also that copyright is meant to protect against plagiarism that's on those books. And so when you're putting that in, you're giving the credit to who created it, but you're also making sure that you're not using a copyrighted piece of material and presenting it as your own. That's why it's important to note where you get your information from when you're using information that comes out of another source. Ownership of a copyright is the author of the copyrighted work will be the owner in most cases. And that ownership can be transferred in whole or part. That's selling a license to it or giving the full ownership of the copyright. Infringements when you use someone's copyrighted material without their authorization. The copyright for most textbooks allows for the use for educational purposes, as long as you are giving credit where it needs to be for those purposes. The remedies for copyright infringement can be an injunction, impoundment and possible destruction of infringed articles, actual damage plus profits or statutory damages, the cost, and criminal penalties. There's a lot that goes into it. And the reason that you have to be real careful with copyright is because of all this. You can lose your work completely, pay damages to them, whatever damages it may be, plus any profits you've made off of it. So money you made off of it will become their money. And statutory damages are possible in some cases. There are some statutes that state what can be done, plus the cost of the use of that, their court costs, those type of things. And then there are certain criminal penalties that come with copyright infringement. A patent goes a little bit deeper beyond that. So a patent has to do with inventions, and it's the exclusive right of the invention for 20 years from the date of application for utility and plant patents, 14 years from the grant of that patent for designs that are done. For something to be patentable, It must be novel. In other words, there's not any of it around. Something new, something that's not commonly used, useful in some way, and not obvious. Okay, so something that's not like everybody would create that. It's just common to do that. So those type of things are what they're looking at. Usefulness means it has to be useful in the market you're trying to put it into. There has to be some actual use that the general public would get from this item, or if it's a niche type item that businesses working within that environment would be able to use. There has to be some useful intent with there to get a patent. Patents aren't extremely, they may not be extremely easy, but you can get those. A lot of companies that produce equipment, tools, computers, those type of things, they'll have a lot of patents going at one time, because what they're doing is they're getting the ideas that they have out. They're getting the thoughts that they have for an item, for a new version of something. Like each time there's a new version, there's a new patent for it. And so they're re-upping that so that they can create new and keep moving forward. And they'll get a patent for it. And it may be something as simple as a change in the mechanism of how a box opens, a change in the latch of it, or in, the way that a cup is sealed, a change in how that's done. A new patent would come out, this is an improvement upon it. So they're getting a new patent for it. Patents are issued upon application and after the examination of the U.S. Patent and Trademark Office. The examination is looking to make sure it's novel, useful, and not obvious. They're wanting to make sure that those things are, in place and it works like it should. When someone infringes upon it, they're using it without permission. They make, use, or sell a patented invention. You can search patents, and this is where that protection has to be in place, because you can search out patents, and there's designs in there and a lot of things involved in how they're doing something as far as a new item comes out. So it's real important to make sure those protections are in place. That infringement is protected, and you can get injunctive relief. Once again, damages, treble damages where appropriate, attorney's fees, and cost of whatever it costs them to go to court outside of those attorney fees. So you'll end up paying a lot of money when you infringe upon someone's patent, because attorney fees are not cheap, y'all. All right, it's intellectual property in a table. So what's protected under trade secrets and trade symbols and copyrights and patents? Let's look at copyrights. We'll spend a little bit of time with that one. Your work of authorship is what you're protecting. So you're protecting your authorship when you get a copyright. You're protected against any reproduction of it, any type of derivative work for it, any distribute, performance, or display of it. You're allowed to do it, and only those that you give that license to, or that allowance under copyright to, do those things. The duration is the author's life plus 70 years, so a good long amount of time in there, especially if you're a younger person and you get a copyright at a younger age. It's going to be protected for quite an amount of time. It is federally protected. The only thing that's not federally protected here are trade secrets, but you can go to court to get those protections and get some damages from it if someone was to infringe upon it. Trade secrets is a valuable secret. So every one of these has a monetary value to a certain extent, the money that could be made from an item that you have a patent on. So you have future value in a patent. A copyright has whatever current value plus what you could possibly make from it. Trade symbols are the value in not only your the money made from that trade symbol, but your reputation, those type of things. Trade secrets, on the other hand, exceed the value in all these, because this is how your corporation runs, how you run your business. Things that you do to keep your business running and make your business profitable, those can be your trade secrets. So those carry an intrinsic amount of value way beyond what maybe the possibility of what you could make with a patent. When you get a patent for something, just because it's approved for a patent that they consider it to be novel, useful, and not obvious, doesn't mean that you're going to make money on it. There are a lot of patents that have gone through the patent office that never made a dime. So, it's not a guarantee that you're going to, get rich with a patent, or, you're going to make money off of it. Same with copyrights. You can produce as many books as you want and copyright all of them. They may sit on the bookshelf at Second and Charles and never leave off the bookshelf in the markdown section. That book that was originally $45 may be in the markdown section for $2 and sit there until they donate them to a library or something. Trade symbols, they have some intrinsic value because you're using those as a symbol of your corporation, your company. Whether or not your company's making money, that's how much that symbol is going to be profitable. Trade secrets are how you're running and doing and whatever. And you don't care about protecting those until you start making money. So trade secrets are valuable because they're protecting how you're making money. And that's where the value on those come from. All right. So that is intellectual property in a nutshell, not a deep dive into it. The book just has a small chapter on it. So it's not, we didn't go into it and get into all the different pieces and parts of how that goes. But if you have any questions on it, please let me know. And until next time, stay safe and study hard.